SCOTUS's immunity decision undermines Congress. Welcome to Law and Society. Please subscribe and let's get started. In the previous video about the SCOTUS's immunity hearing, I summarized the hearing and talked to you fundamentally about what the case says. I talked about what would be the immediate short-term movements of repercussions of the immunity ruling, that Judge Chutkan has to set up an evidentiary hearing. She has to ask for briefs from both the parties on the matter. And Jack Smith also has to amend his indictment to be able to conform with the Supreme Court's ruling. So those are the immediate things that are going to be happening in the next few weeks and months. We are going to see an evidentiary hearing, and the evidentiary hearing will bring up topics that American people need to know. But today I want to tell you, I can't stop thinking about it, right? So I can't stop thinking about the immunity that SCOTUS has just created out of thin air and given to POTUS. In a way, the Supreme Court decision that immunizes the president for his official acts and attaches a presumptive immunity for all his official acts essentially puts him above the law, as Justice Sotomayor said. And although, as Amy Coney Barrett wrote in her concurrence, this is a two-part judicial review where there's a presumption of immunity and then can be rebutted by the government. The rebuttal and the overcoming that burden of proof is a much higher standard than to be able to say that no, he doesn't have immunity after his core functions. The core functions, nobody contests that he has, presidents have immunity and former presidents, in this case, gives that immunity. That's perfectly fine. But for other acts that are presumptively immune, so you're giving the precedent a leg up, and that undermines Congress, because Congress is the body that writes the laws, makes the laws. And then the president signs it into law. But if the president vetoes it and it goes back to Congress, Congress can re-vote on that law and pass it by supermajority in a veto-proof majority. So Congress is the law-making body. And what the Supreme Court has effectively said is that for any criminal action to be taken against the president, there is a blanket presumption of immunity, and that the prosecution has to overcome. So that is, in my opinion, a big damage done to the balance of powers. And it is also giving the judiciary more power to interpret what the law is. So not only are you saying that this law is not on its face applicable because of the president's presumptive immunity, you're also making it difficult for you're also giving the judiciary the power to interpret that law how they see fit. So Congress is taking a back seat here, where on one side the president becomes presumptively immune, and the judiciary gets to review whether the government or whether the enforcement branch, which is the part of the presidency, gets to bring those cases and have to overcome the presumption of immunity. So before this case, the prosecutors didn't have to overcome the presumption of immunity, but with this case, you have to. So that itself puts the judiciary and puts the presidency in a place where they play together, and they sort of assess what the law is. The president does something that is violating a certain law, instead of saying that this is a violation and he can be held liable automatically upon leaving office. It has now become that if the charges are brought, there's a presumptive immunity that attaches to presidents, and the prosecution has to overcome that. So there is there really is a lifting up of the judiciary and the executive branch and a pushing down of Congress. And I think that's a dangerous step forward because if Donald Trump and MAGA reach the majority of Congress and the presidency, well, they will change the United States as we know it today. Our rights will be curbed, and our free speech rights will be curbed. Our privacy rights, which have clearly already been eviscerated by the Terry line of cases, that will be gone. I don't know what will happen to our jury trials and our other rights under the Bill of Rights if Donald Trump's regime comes into play. Because Donald Trump's regime would, under if Donald Trump orders arrests of political opponents or arrests of people under some official auspice of power, first of all, he can't be prosecuted as he's sitting there. And if Donald Trump ever leaves office again, that would mean that there would be a presumption of immunity over all of the actions that they've taken that the successive prosecution would have to overcome before they can actually get to the president's private acts, or the presumptive nominee can be broken and saying that these official acts weren't official acts to begin with, they were private acts under color of official acts. So it makes the government's case that much harder to prosecute a former POTUS. And I think that's a dangerous step that we're taking. And, it syncs with Justice Sotomayor's admonishment that this puts presidents above the rule of law. It really does. And it also does put the judiciary one step above Congress. So Congress needs to, what we need at the moment is a heavily blue Congress. If we can get a heavily blue Congress and President Biden wins re-election, then everything from Roe versus Wade to the regulatory state, they can be legislated. There can be legislation that adheres to the Supreme Court's rulings on these cases and clarify, even on immunity, even on presidential immunity, they can legislate to say what the law is and what laws, under what laws the president becomes liable and what laws they do not. It can codify Roe versus Wade. It can, having a blue Congress and a blue president would give America the progressive push it needs to move into a paradigm where we take care of each other's rights, where we grow the country from the middle class out, where we don't deprive people of medical care because they have pre-existing health conditions. We don't separate children from their families at the borders because that is what the president thinks is sound immigration policy. We don't drill indiscriminately like former President Trump wants. We take a scalpeled approach to energy production, and we save and secure the areas that are pristine nature, and then we go to places that would not have as much of an impact to the atmosphere and to the ecosystem, and that's where we get our energy from. That's what President Biden is doing. On the other hand, Donald Trump or a red Congress would go headfirst into all areas of production of oil and gas, and that would bring I think that would bring inflation down in the short term, but that would ravage our planet. That would cause climate catastrophes left, right, and center, not just in the United States, but all over the world. So the implications of this immunity case, were the wrong parties to get into power, are enormous. It can undermine Congress by presumptive immunity. It can delay and stave off accountability in courts because of the proceedings to prove to overcome the presumptive immunity. So it creates a mess, and not to talk about the mess that the overruling of the Chevron doctrine brought about in the other, I think it's Loper Bright case. And so the government has an uphill battle. And then you have the Fisher versus United States about the obstruction statute related to January 6th. The DOJ has their work cut out for them, and they need to get to work and be able to balance out in the immunity case parts that are official and unofficial, and be able to still hold Donald Trump accountable under the narrow approach of the Supreme Court. Because if this immunity ruling ends up to a point where Judge Chutkan and Jack Smith says, well, they've left us nothing to prosecute Donald Trump with, that is an ominous, ominous sign, because the court itself said that there are parts where Donald Trump acted in his private capacity. So, with that said, I think I've gone off to the substance of the case again, as opposed to talking about the larger impact. It's a hodgepodge, you know. It's the rogue Supreme Court has put us in a hodgepodge, not just in the immunity case, but also in social rights, in reproductive rights, also in the regulatory state. So this is a rogue SCOTUS that has gone completely off the handle, and it has taken the presidency along with it and left Congress to its own devices. So we'll have to have a strong Congress and a blue Congress if we can push forward with this sort of an encumbrance put in its way by the Supreme Court itself. So with that said, thank you so much for being here. And please like and subscribe if you're new to my channel. Your input and your comments help me and gives me an idea of what I need to talk about. Somebody wanted me to talk about the Chevron doctrine. I am not well versed on it. I don't have a working knowledge of the administrative law section of constitutional law. So I can't give you an accurate assessment of the Chevron case. But the short story is the Chevron doctrine deferred to regulatory agencies how to interpret the laws given by Congress. Now, the Supreme Court has said that the courts don't have to give these regulatory agencies the Chevron deference, that they can look at the way that the agency has applied the law independent of how the agencies have defined them, and then they can interpret the law to say that the agencies had this wrong. So it opens up the regulatory state for judicial review, and it encumbers it really encumbers regulations, you know, and in a way it will impact the safety of Americans, because these agencies, everything from the FDA to the IRS, these are all federal agencies, and the DOJ, they are regulated by laws, and they interpret the laws as they are regulated, of how to regulate themselves. Now the court under Chevron has said, no, the courts have review over how you are interpreting these regulations that establish your agency. So that's the hodgepodge there. With that said, thank you so much for listening, and I'll talk to you soon.